Civil procedure. Joining and handling multiple parties and claims. With a view to settling as many disputes as possible in the most efficient economic manner, the US courts are very lenient about joinder of claims. A plaintiff may join as many claims as he has into a single action. Totally unrelated claims of assault or negligence, for example, can be added to a suit for breach of contract. In fact, unrelated claims are often aggregated to meet the $75,000 amount in controversy floor necessary to get into federal court on grounds of diversity of citizenship. However, when any new claim is added to a lawsuit, it must qualify for personal jurisdiction, subject matter jurisdiction, and venue. Joinder in the suit follows qualification by the court on a claim-by-claim basis. A counterclaim is made by the defendant against the plaintiff. It's often included in the answer to the complaint. Counterclaims come in two forms: compulsory and permissive. A compulsory counterclaim is compulsory. It must be claimed, otherwise it's waived and forever lost. Claims arising from the same transaction or occurrence are compulsory. To determine what constitutes the same transaction or occurrence, the courts consider whether the claims involve the same evidence, the same issues of fact and law, and a logical relation between the claims of the plaintiff with those of the defendant. A permissive counterclaim is not compulsory, but permissive. It may be brought, but no rights are waived if it's not brought in this action, and is instead brought in a separate later action. Federal courts rarely grant supplemental jurisdiction to consider permissive counterclaims, as they're not directly related to the case at hand, and they do not arise from the same transaction or occurrence, so should be dealt with separately in state court where necessary. A cross-claim is a claim brought against a co-party in the same side of the lawsuit. That is, a plaintiff brings a claim against another plaintiff, or a defendant brings a claim against another defendant. The policy for allowing cross-claims is that they promote efficiency and consistency. It's more efficient to allow cross-claims than it is for the courts to try each claim individually and relitigate the same facts. A cross-claim is not compulsory, but it is possible for any defendant to make a cross-claim against any other defendant, and for any plaintiff to make a cross-claim against any other plaintiff, even those that have been recently joined in the action. The cross-claim must arise from the same transaction or occurrence. It cannot be for matters unrelated to the case at hand. As it arises from the same transaction or occurrence, the cross-claim should qualify for supplemental jurisdiction. This is often useful to know when checking that each claim qualifies for subject matter jurisdiction. The courts can only consider claims within their subject matter jurisdiction, so each cross-claim added into a case before federal court has to qualify for diversity, federal question, or supplemental jurisdiction. Some parties must be joined in the case in order for the court to settle the matter conclusively. The courts want to avoid duplicative cases and try to settle as many matters as feasible in the same action. But if the case is too complex or makes no sense to consolidate actions, the court has the power to deny consolidation and try the claims separately. All indispensable parties must be brought into the case. An absent party is considered necessary and indispensable if, without joinder, the court cannot award complete relief. The absent party himself may be harmed, or failure to join subjects the defendant to double claims. The exception here is joint tortfeasors. They're not considered indispensable, and separate cases can be brought against each tortfeasor. As well as the parties that must be joined, there are other parties that may be joined. Plaintiffs may sue together and join defendants together for claims arising out of the same transaction or occurrence, and claims involving common questions of law. Adding a new party can break diversity in a federal diversity case. So judges always check for subject matter jurisdiction when new parties are joined. An impleader involves a defendant joining a third party as co-defendant. The third party can be joined if they're liable or may be liable to the plaintiff for the harm caused. An example is a restaurant that's sued by a customer for food poisoning that joins the third-party supplier of the poisoned food into the case. Via the defendant restaurant, the impleaded food supplier has caused the harm to the plaintiff, is liable directly to the plaintiff, and in fact pays the plaintiff directly when judgment is served by the court. Defendants cannot simply join new defendants to add new targets for the plaintiff. Impleader doesn't allow the defendant to bring in a party that caused the harm directly to the plaintiff. The third party must have caused the defendant to harm the plaintiff. Alternatively, a third party that can be liable to pay for the harm can be joined by impleader. So impleaders are seen in cases involving products liability, where the retailer brings in the manufacturer supplying the product that caused the harm. Insurers are also brought into cases on the basis that they're liable to pay for the harm. The impleaded party pays the plaintiff directly, not via the original defendant. In our example, the food supplier would be liable to pay the restaurant customer directly. The defendant has a right to implead the third party within 10 days of the answer, and can request court permission to implead at a later date. Like all defendants summoned to court, the impleaded third party requires fair notice and service of process is required. The third party defendant must be served with a third party complaint. The bulge rule applies and allows for service on impleaded third party defendants who are not in the state but found across state lines within 100 miles of the court. Of course, after being joined as a defendant, the impleaded third party is able to file claims against the other parties in the case. As long as they arise from the same transaction or occurrence, the plaintiff can file claims against the impleaded third party, and the impleaded third party can file claims against the plaintiff. The court's jurisdiction over the parties is determined on a party-by-party basis. The court's jurisdiction over the subject matter is determined on a claim-by-claim basis. Complete diversity jurisdiction of the federal court is broken if the claim goes across the docket from the plaintiff's side to the defendant's side, and the two parties are from the same state. However, two parties from the same state can be on opposite sides of the docket, so long as there are no direct claims between them. If the impleaded third-party defendant and the plaintiff are from the same state, diversity is not broken if there are no claims between these two parties, and the claims instead go from defendant to defendant. When joining the third party as defendant, the court will again need to validate jurisdiction over the party and jurisdiction over the subject matter of the claims. Adding the impleaded third-party defendant can break the diversity jurisdiction in federal court, but this is determined on a claim-by-claim basis. If a party wishes to voluntarily join a suit, the process is called intervention. If the absentee party has a right to join provided by statute, or is claiming an interest in property that's the subject matter of the suit, the party has a right to intervene so long as his interests are not being represented by the existing parties in the case. Otherwise, intervention can be by permission of the court, where the absentee party shares a common question of law or fact. Agents of the federal or state governments sometimes intervene in cases where they have a right created by statute, or the case involves questions of law or fact that are common to the state's interests. An absentee party can intervene as either plaintiff or defendant. Again, existing parties to the suit need adequate notice, and service of process is required. There are no specified time limits in the federal rules, other than a requirement that intervention must be timely. Intervention is generally not allowed if the newly added party breaks the rules of complete diversity in a federal court diversity case. If an opposing party is from the same state, the intervention will be rejected by the court. There is a possible exception to this rule to protect defendants in an intervention of right situation. An absent defendant is sometimes allowed to intervene in a diversity case, even though this breaks the rule requiring complete diversity. The exception does not apply to third parties intervening as plaintiffs, and it does not apply to permissive intervention, only where a defendant is joining via intervention of right. An example may be where the third-party defendant is liable to lose ownership of property that's the subject of the suit. Intervention can be allowed via the invocation of supplemental jurisdiction after the court has weighed issues of prejudice and other factors. Where an insurer could be liable to pay out twice on the same policy, perhaps involving a dispute as to who should receive the proceeds of a life insurance policy, the insurer does not want to pay one party only to find it's liable to pay the other party. This would expose the company to double liability. Interpleader is a process where the plaintiff can join two or more defendants and ask the court which one should receive the property. The plaintiff can join the defendants to avoid exposure to double or multiple liability. There are special statutes allowing the court to join parties in interpleader actions from across the country. Special long-arm statutes, personal jurisdiction, and venue statutes give the court extended reach to join parties from different states to resolve the question of which one should receive the property subject to the dispute. A class action is a lawsuit brought by a representative member of a large group of people on behalf of all members of the group or class. This form of collective lawsuit originated in the United States and is still predominantly a US phenomenon. In order for the case to qualify for class action, all four of the following factors must apply. Numerosity. Firstly, the class must be so numerous that joinder is impractical. There's no magic number here, it's whatever is impractical for the court. Obviously, 100 plaintiffs is too many, but 20 plaintiffs might be arguably practical for joinder instead of class action. Commonality. The second requirement is that the claims involve common questions of law or fact. Typicality. The representative plaintiff must be typical of the class. And the fourth and final factor is adequacy. The representative and the lawyer must fairly and adequately represent the whole class. There are three types of class action in the United States today. A prejudice class action allows the members of the class to join a single action in order to prevent prejudice to any one member through inconsistent judgments or an inability to protect their interests. The idea is to prevent members of the same class being treated differently by different courts for what is essentially the same claim. Injunctive class actions are applied where an injunction might affect a whole class, rather than a small group or individual. The remedy sought in a damages class action is not an injunction but money damages. For the plaintiffs to qualify for a damages class action, common questions of law or fact must predominate the case, and the class action must be the best available method of resolving the dispute. Are members of the class notified of the action? No notice is required for prejudice or injunctive class actions. There's no point in providing notice as the member cannot opt out. As they can't opt out, all the members are bound by the judgment. The court will, of course, notify the members of the class of a settlement or dismissal of the case. Class actions claiming damages are different. Notice is required when money is involved. Individual notice via mail is required for all members reasonably identifiable in a damages class action. The notice to members in the damages class action informs them of their ability to opt out of the action if they wish. It informs them that if they join the class action, they're bound by the judgment and cannot then make a separate claim if they're unsatisfied with the outcome, and they have the right to make a separate appearance if they prefer. It may be impossible to have complete diversity in a large class action. At least one plaintiff citizen of the same state as the defendant will break diversity. There's a special rule here, and the court looks only to the citizenship of the class representative. As for the amount in controversy, the courts are split. Some say that each member of the class must claim more than $75,000, and others say it's okay if the representative claim is more than $75,000.